This Archbishop Thomas Manambarambil, Archbishop Anil Jekuto, and other esteemed dignitaries on the dais, starting with our provincial and the Vice Chancellor for Stani, and all the dear fathers, sisters, and our friends sitting in this auditorium commemorating the Swarna Jayanti of Vidyajyoti. I'm in a way honored to be part of this celebration right from its inaugural session. As Father Nirmal Rai said, I have a very close association with Jesuits, mainly through the All India Catholic University Federation. I was its senior leader and still I continue my association in ICAP through our old leaders. I was part of a couple of lecture series marking the 450 years of Jesuit presence. And I must congratulate the organizers in having chosen the theme, the role of theology in nation building, in connection with this Swarna Jayanti. Quite mischievously, I was just trying to quibble. Probably the judges would be interested in telling the role of courts, the role of judiciary in theology building, going by the number of cases we are before the courts, asking them to interpret our theology. Well, I would generally like to speak about the Constitution and its constitutional values. Director has asked me to concentrate on those aspects. Ours is one constitution which starts with the word we the people of India. And this has been interpreted to be the key words in the Constitution of India, which actually defines the Constitution of India. It's in the preamble, the first word, and it's actually taken from American Constitution. American Constitution is just this small book, just 7 articles. We have a preamble and 395 articles as of now, with so many amendments in between, like amendments in the Income Tax Act, adding A, B, C, D, etc. Just like the number of congregations, one does not know. So also the Income Tax Act, one does not know the number of amendments. The Jubilee Finance Act introduces amendments. If you also are familiar with that, so it just cost this, and it just started with this day, it goes like that. So this Constitution, American Constitution, they just had 7 or 8 amendments with the 7 articles, and we have crossed the century. We have touched the century. I think we are in the 107th or 17th. And myself, I am not able to keep abreast with the amendments we are introducing. It's a sign of growth as well, indicating that we are not that rigorously scrupulous over the text, but we indent the spirit of the Constitution. So we, according to the needs of our, like the need of the hour is the will of God, the need of the hour is the will of the people. So we try to amend the Constitution, and we have reached so many, crossed over 100 amendments in the process. The one amendment which has not been attempted so far, though there are impending threats for such an amendment, is on the framework of the preamble. Because preamble is called the jewel of the Constitution. It has actually come from Pandit Nehru's original objective resolution. The preamble's origin is actually from Pandit Jawaharlal Nehru in the Constituent Assembly. Well, I am happy to note that one Jesuit father was there in the Constituent Assembly, Father Jerome D'Souza. We had 299 members in the constitutional in the Constituent Assembly, of which 15 were women. Only 15 were women. It took 2 years, 11 months, and 17 days to have this constitution drafted and finalized in the Constituent Assembly. 299 members were there in the assembly as well. Yes. So we discussed threadbare, because ours is a constitution which is actually taken from so many sources, mainly from US. We took the preamble. The US constitution is the one constitution, the preamble starts with the word B. And ours is the lengthiest written constitution in the whole world. So we took B from there. We took something from USSR, at that time Union of Socialist Soviet Republic, yes, at that time. Now it's only Russia. So we took the what they call rights from that side. We took a lot of things from France also. I speak to the constitutional values, I speak. We took something from Ireland also in the constitution. In fact, the directive principles of state policy we took from the constitution of Ireland. Rest all from interestingly, fundamental duties, in fact, we got it from Russia. Well, in the constitution, I said, it's such an inclusive in its nature, because India is the very existence of India, or the very definition of India, or the very idea of India is unity in diversity. It's a unity in diversity. It's actually union of states. There are a lot of discussion as to whether this should be a federal state. Federal means like in America, each state has its own autonomy and the provincial autonomy, and then they become into a federation. There's a lot of discussion on that, but finally Dr. Ambedkar prevailed upon all others in the Constituent Assembly, saying that provincial autonomy should be a limited autonomy. It should not be an absolute autonomy. So we'll have a union of states. So because India has so much of a diversity in its very, very life. As of now, we have 22 scheduled languages, 1,147, if you go by the website, 147 non-scheduled languages. We have all world-known religions, 9 of them. We gave birth to 3 of them, Buddhism, Jainism and Sikhism. We have welcomed all religions. Christianity was welcome, Islam was welcome, Zoroastrians were welcome. So India, by its very nature, was inclusive in its life as such. And we have the civilizations, all world-known civilizations were in India. So it's a conglomeration of all put together, that is what is India. So it is not the unity of India does not depend on the uniformity. This is the point I wanted to say. Uniformity was never the sine qua non, or was never the idea when India was formed as a union. It always existed, and it wanted to exist, and it will exist, and it must exist as a union of states with all its diversities. You cannot suppress the diversity and make it a uniformity for the sake of unity. And I repeat, unity is not necessary for uniformity. Uniformity is not necessary for unity, and Catholic Church is the best example for that. Look at the diversity of Catholic Church across the world. Look at the diversity of Catholic Church in India. Look at the attempted diversities within the Catholic Church, within the denominations also. So everywhere, we have an inclusive approach and inclusive idea as far as India is concerned. Cultures, civilizations, languages, religions, political parties. One does not know how many political parties we have in India. Of course, the election commission has its registered number. But there are ever so many, because everybody wants to either become a prime minister or a chief minister. So the number would go on increasing. That's the whole problem with Indian opposition as well today. This may not be found place in the text that you mentioned. I told Father I will only speak externally. So this one sentence, probably with opposition, you may not find the place in the text when you draft. But that is a fact. So many among the opposition leaders want to become not less than a prime minister, at least for a short time. And that went into the splinter groups being generated from one party to the other. They can't think of a unified opposition for the sake of democracy, not for the sake of anything else, democracy. Because democracy is nothing without an effective opposition. Well, so they coming back to the constitution. We, the people of India, having resolved we resolved to constitute India into a sovereign, socialist, secular, democratic republic. So the beautiful part of this aspect is that we resolved, nobody else resolved, we resolved and we constituted. So I am a constituting factor of my country. Without me, country is that much void. So I cannot be kept out in constituting I am a constituting factor. So that's what makes me a proud Indian, because I am an Indian and without me, India is incomplete. This is the idea that the constitution makers wanted to have, being so inclusive. So we resolved to constitute India into a sovereign, socialist, secular, democratic republic. Of this, the original constitution when we drafted and which came into effect in 1950, January 26 completely. Partly it came into effect on 49 November 26, completely on the Republic on 50 January 26. These two words, secular and socialist, were not there. We are only having the three preambular, pillars, which are sovereign, democratic, republic. Sovereign democratic republic. It took care of everything. That was the idea. Though there was a discussion, Professor Shah wanted the secular to be included in the constitution while it was drafted. It was not. It was agreed that it is otherwise secular. Why do we want to include? And Dr. Ambedkar was against the socialist being included in the preamble, because according to Ambedkar, socialism is an economic principle. And it should be left to the people whether they want to be socialist or capitalist. So it's not for the constitution to conceive the country of a socialistic pattern, but let the people decide whether it wants to follow the economic policy of being a capitalist or a socialist. So he was against. But after 20 years, and that too in democracy, in emergency, comes included. In emergency, there was a very famous 42nd Amendment to the Constitution of India. Majority of them, the autonomy of judiciary, independence of judiciary also was compromised. But all those amendments were stuck on. But a couple of amendments, or rather 3-4 of them were retained. One major retention in the 42nd Amendment, which were all scrapped thereafter in the 77 Parliament. One retained was that the introduction of the word secular and socialist were retained in the preamble. This has some significance, that's what I'm saying. See, there's something called a concept called basic structure. Basic structure means a structure with its basic pillars. So if one pillar goes, the one column goes, the whole structure goes. So the sovereignty of India, democracy, socialism, secularism, republicanism. These are the 5 main pillars on which this country stands. So one pillar, if you remove, then the whole structure will fall, because it is so put up in such a way. So there is an argument now being introduced that which was something which was sought by an amendment should be removed by an amendment. So which is introduced by an amendment is secularism and socialism. Therefore, there is an argument in some fundamentalist groups that secularism should be removed from the preamble to the Constitution of India. That's the only place where this word secular comes in the Constitution. The whole Constitution is only in the preamble. So they say Hindustan, being the country, it need to be secular and the secularism should be removed. There is a fundamentalist approach like that. But fortunately, the Supreme Court of India has held in Kesavananda Bharati. That's the highest number of judges in any constitutional judgment. and just for your information, constitutional bench judgment means a bench which consists of 5 or more. Because under Article 145 it is written that any major issue concerning the interpretation of the Constitution shall be decided by a bench of minimum 5 in the Supreme Court. So any bench which of 5 and more are called constitutional benches. So if 5 is to be reconciled, goes to 7, 7 to 9, 9 to 11, 11 to 13. The Kesavananda Bharati case regarding the basic structure issue was of 13 judges. It has not been reconsidered so far. That decision it has held by the Supreme Court as secularism is a basic structure to the constitutional bit. So if it is basic structure, it is beyond amendment. This is the importance. If it is something is the Constitution can be amended under Article 368, but there are certain things in the Constitution which cannot be amended because then it will cease to be a Constitution of the country, the way it was conceived to be, or the way it was conceived to come into existence. Therefore, it has been now laid down that there are certain basic structures in the Constitution which is beyond the amending power of the Parliament. So, secularism is one of them, socialism is one of them, the pattern of country, democracy, sovereignty, republicanism, constitutionalism, rule of law, independence of the judiciary. All these are basic structures held to be, because it's a contribution by the judiciary. It's a jurisprudence actually developed by the judiciary while interpreting. Because in one of the judgments, a constitutional bench in Manoj Narula, I myself have said that what the Constitution is, it is for the court to say. What the Constitution should be, it is for the people whom you vote or we vote to make it to the dreams the makers have. So therefore, it is now, secularism now is beyond the amending power of the Parliament. So when a secondary stands, it should be the unless that decision is overruled. One does not know when it's going to be overruled also. Right. So, and the one unique aspect of Indian secularism is that it's not as if in other countries secularism is defined in many countries where it is a total non-interference with the affairs of the state, and vice versa also. There's no, it's religion, state. But as far as India is concerned, India recognized the role the religion can play in making a person a better person and a citizen, more responsible citizen. This is the role of the religion. Therefore, it gave a proactive role. It recognized the proactive role the religion can play in molding the nation, in building the nation. So, therefore, in the Constitution, as a fundamental right, we incorporated right to freedom of conscience and freedom of religion. We have this, you can believe in a religion, you can refuse to believe. But if you believe, you can profess it, practice it and propagate it. 3 fundamental rights are given, subject of course public order, health, morality and the fundamental rights in the Constitution. So subject to all these simple 4 restrictions, public order, health, morality and other fundamental rights, every person who believes in the religion has a right not to believe, but to profess it, to practice it and to propagate it also. Here comes that big issue of the conversion issue, conversion enactments also. To avoid questions from you, see, anti-conversion laws are only laws only to prevent a forced conversion. So it does not in any way interfere with the fundamental right of a person to be converted. It only regulates the right of a person to convert another person without his free will. This is the sum and substance of that issue. Let me come back to the 5 principles. So, sovereign. Right. Yeah. So we have the five main pillars on which we stand, and then and to secure, the Constitution says the secure to our system. So we are going to secure this Constitution built on these 5 pillars is going to secure or assert to secure to citizens what? To citizens, one is justice. Justice is social, economic, and political. Social justice, because India, there's a lot of social discrimination, or rather, a lot of discrimination on the basis of caste, color, creed, language, religion, political, gender. All all these are the discriminating factors which are the realities in India. Probably one of these days you might have seen a video, a girl being thrashed for having taken bath in Ganga. I don't know whether you are asked to it, but I just saw it. See, there's a lot of discrimination. All said and done, there are discriminations on the basis of caste, color, creed, language, place of birth, gender, all. So, in order to remove all this, we made it a point to have a constitutional value of justice, which is social, which ensures social justice, economic justice. Again, reduce the inequality as far as possible, and to have an equitable distribution of the assets of the country. This is economic justice. And political justice is actually intertwined with, rather closely associated with the democratic rights of freedom. That is first justice. So first constitutional value is justice. Then liberty. Liberty has 5 integrated elements in that. Liberty of thought, expression, faith, belief, and worship. All these liberty of thought, expression, faith, belief, and worship. All these 5 liberties are guaranteed in the Constitution, and the particular guarantees you will be able to see in the fundamental rights part. That is part 3 of the Constitution. Starting with the Article 14, equality. All are equal before law and equal treatment before law. It goes up to Article 30. 31 was under Article 30 with the minority rights. Up to that, all these liberties of majority community, minority community, all citizens have been enshrined in the Constitution. That is liberty. Then comes equality. Equality is the major, the most important article. If you ask me the most important article in the Constitution of India, I would say it is equality. Article 14, equality before law and equal treatment before law. And there are only 2 fundamental rights which are available to all persons, not to citizens. Only 2 articles in the fundamental rights available to all persons who are in the country. You are a foreigner, you are a citizen. These are Article 14, equality, and Article 21, right to life and liberty. These are the 2 articles that are available to all other persons as well. So that is equality. Your right to equality does not depend on what you are and what you have. This is the sum and substance of the equality clause. And comes the fraternity. This justice, liberty, and equality. These were actually taken from the US Constitution, USSR Constitution, and England also. Britain, they were conscious more of the rights also, the right, and of course the French Revolution slogan of the justice, liberty, and equality. Then comes the fraternity. Fraternity is taken as a duty, and this part we generally owe to Russia. It is taken from that side also as a fundamental duty to a fraternity. In the original Constitution, when it came into effect, fraternity only had this word, fraternity, assuring the dignity of the individual. In the preamble, when it started, it wanted to secure to all the citizens justice, liberty, equality, and fraternity. When fraternity is further defined, fraternity assuring the dignity of the individual. Because dignity in India was it's a big question, because everybody was not entitled to equal dignity because of the social structures, because of the communal structures we had in India, which have gone to touch roots in the country. That therefore the caste system always had a different levels of dignity attributed to them on account of their origin to a particular community or a particular caste. So India was quite conscious of it. Therefore, it said the fraternity, all of this, India is my country, all Indians are my brothers and sisters, irrespective of caste, color, language, sex, place of birth, language, or place of origin. Place of origin, right? So, irrespective of all these discriminating factors, we wanted to say we are all brothers and sisters. And this was one of the most important speeches ever made in the world by Swami Vivekananda when he addressed Chicago. Sisters and brothers. Then he had to explain what the meaning is. That the meaning actually comes from the Indian concept of treating everybody equal, irrespective of the discriminating practice. Well, in the Constituent Assembly, in fact, if you ask me, the least discussions were held only on the preamble. There was not much of a discussion. Of the 2,473 amendments discussed in the Constituent Assembly, maybe only a couple of them related to this preamble, and nobody ever had any dispute with regard to these aspects of justice, liberty, equality, fraternity, except whether the social justice should be included or not was the question. But finally, when it was presented by Dr. Ambedkar that this is going to the preamble, everybody accepted. But there were very heated discussions on various other articles in the Constituent Assembly, but not much regarding the preamble and the constitutional values. And in the emergency, just as secularism and socialism was included, preamble was also amended. There are only 2 amendments in the preamble. That amendment in the 1976 post-emergency, during emergency, amendment 42nd is unity and integrity of the nation was added. Dignity, that is because there are a lot of aspects they had to discuss regarding the security of the nation and the unity and integrity of the nation. If somebody is a threat to the unity and integrity of the nation, then the concept of fraternity will have to yield to the unity and integrity of the nation. That was something which was introduced when the fundamental rights were sought to be suspended during emergency. So, my dear friends, my time allotted to me, Father Edwin, is almost over. But I just wanted to say, this preamble in Indian Constitution is the most important facet of our Constitution. I just wanted to read out one small paragraph from the Kesavananda Bharati judgment, where this aspect of the preamble has been dealt with, and this, the author of Kesavananda Bharati, I think 9 judges are authored separately, and Justice Jaganmohan Reddy, yes. I just read out and close my speech here. The preamble is a key to open the mind of the makers as to the mischiefs which are to be remedied. B. That it is properly resorted to where doubts or ambiguities arise upon the words of the enacting part. C. Even where the words are clear and unambiguous, it can be used to prevent an obvious absurdity or to a direct overthrow of the intention expressed in the preamble, and it would be much more so if they were ambiguous. D. There is no reason why in fundamental law or constitution of government an equal attention should not be given to the intention of the framers as stated in the preamble. E. The preamble can never be resorted to enlarge the powers expressly given, nor to substantively create any power or to imply a power which is otherwise withdrawn from the Constitution. Its true function is to expound the nature, extent and application of the powers actually conferred by the Constitution. I read out this because whenever we have any doubt regarding the interpretation of any article in the Constitution, we always refer it to the preamble. What is actually the whole idea of our Constitution? So, constitutionalism is the basic idea. That means, come what may, we have to follow a constitution. And we are guided by rule of law, and that is constitutionalism. And it is this Constitution of India, which keeps the country as India even as of now. But for this Constitution, which has webbed us all together, with all its diversities, India would not have been India as we today. And India expects to be an India for ever, as the Constitution makers wanted it to be. There should be the permanency of the Constitution of India with all its constitutional values protected by the citizens. We, the citizens, we, the people of India. Thank you. All the best and warm felicitations on this honor and the occasion of this Vidyajyoti. God bless you. Jai Hind.